Namaskar. Today we will try to understand the concept of jurisprudence. Student of law often gets confused regarding this concept of jurisprudence because there is not a consensus among jurists and legal scholars regarding this concept of jurisprudence. Still we will try to get general idea about what the jurisprudence is. The word jurisprudence has its origin in the Latin word jurisprudentia, which means knowledge of law. In Latin language, jur or juris means law and prudentia means skill or knowledge. This meaning of words signifies that jurisprudence is practical knowledge of law and its application. In simple words, jurisprudence means studying nature of law. It is study of relation of law to morality and justice, and it is study of relation of law with human society. Jurisprudence is such a philosophy of law which helps to correlate the social values and provides practical solution by way of fusion of facts, justice and values. Jurisprudence is a science of law which is concerned with regulation of human conduct in accordance with the needs, goals and values of the society. For example, there is difference between needs and goals of the Indian society and needs and goals of the American society. Therefore, we can say that there is difference between Indian and American jurisprudence which has developed according to needs, goals and values of that particular societies. So, we can say that jurisprudence is a concerned with study of relation of law with the society, relation of law to social values, needs and goals. The term jurisprudence has at different times used in different sense. Sometimes it has been used as synonymous for the term law, sometimes as a philosophy of law, or sometimes it is called as science of law. But in recent times, it also appears that the term legal theory is preferred to the term jurisprudence. This term has become popular since for the first time it was coined by W. Friedman in his book on legal theory. The term legal theory is generally used in the sense as an evaluative and normative study of concept of law and its relation with the morality and justice which law subserves. Sometimes terms like medical jurisprudence, environmental jurisprudence are also used. Hence, used in this sense, this refers to the study of law dealing with that part of knowledge in that particular subject. For example, when we talk about environmental jurisprudence, it is study of environmental challenges and existing laws to control human conduct with environment to tackle these challenges. Jurists and legal scholar Ogden defines the jurisprudence as any thought or writing about the concept of law, whereas according to jurists Dias and Hughes, there is no proper meaning of jurisprudence. Perhaps the exact connotation of this term is not possible because as a method, jurisprudence deals with concepts which regulates human conduct in accordance with the values, needs and goals of the society. These values, needs and goals vary from time to time and society to society, as also within the same society. These values, needs and goals varies at different times. Let's see another legal theorist, John Austin's view on jurisprudence. Austin says that jurisprudence is a science of law which deals with analysis of concepts of its underlying principles. For Austin, the appropriate subject of jurisprudence is positive law, means law as it is, which means law in existence. For him, jurisprudence is not a moral philosophy of law, but it is a systematic study of actual law as distinguished from moral, ideal or natural law. In other words, Austin has viewed that jurisprudence has nothing to do with law ought to be, or has as how law should be, or jurisprudence has nothing to do with goodness or badness of law, but jurisprudence only deals with what law is or studying of existing law as it is. Austin divides jurisprudence in two classes. One is general jurisprudence and another is particular jurisprudence. Austin defines the idea of general jurisprudence as a science concerned with the exposition of the principles which are common to the different systems of law. For example, the concept of rights and duties, ownership, possession, personality, property, etc. are considered as a part of general jurisprudence because such concepts are mostly common to different legal systems. For particular jurisprudence, Austin says that particular jurisprudence is a science of any particular system of law. Particular jurisprudence is a science of any actual system of law. For example, when we studies Indian or American jurisprudence or Indian or American legal system, in particular, we can say that such a study of such particular system, legal system, comes in scope of particular jurisprudence. For example, the term ownership and possession, which are fundamental concepts known to all systems of law, and it is the function of general jurisprudence to explain such concepts which are common to all legal systems. On other hand, particular jurisprudence does the same thing but with reference to particular legal system of law. General and particular jurisprudence differs from each other not in essence but in their scope. Other jurists, Allen and Gray, also accepted Austin's classification in general and particular jurisprudence, but Gray refers to the term comparative jurisprudence in place of term general jurisprudence. However, Salmond and Jethro Brown repudiates what Austin calls general jurisprudence and holds that particular is the only kind of jurisprudence properly so called. Salmond has opposed to the concept of general jurisprudence because for Salmond, jurisprudence is a science of civil law. He says that general jurisprudence is not the study of legal system in general, but the study of general and fundamental principles of particular legal system. For Salmond, civil law is the law of the state as distinguished from general law. Jurists of historical school of jurisprudence also denied the existence of general jurisprudence. On other hand, Holland objects the Austin's concept of particular jurisprudence. He argues that if jurisprudence is a science, then like all other sciences, it must be general and it is meaningless to call it particular. Other jurists, Stammer, also defined the jurisprudence in same way as it is defined by Holland. Like Austin, for Holland also jurisprudence is concerned with positive law, means law in existence or law as it is. And Holland also thinks that jurisprudence is not concerned with law ought to be or objects of law. Another legal theorist, Gray, also classified jurisprudence in three categories, namely particular jurisprudence, general jurisprudence and comparative jurisprudence. Therefore, Gray adds one more category in John Austin's classification of jurisprudence, and that category is comparative jurisprudence. In modern age, jurisprudence has been treated as science of social control of human conduct, and this idea invariably widened the scope of this concept of jurisprudence. There are mainly four views on these subjects of jurisprudence, which are popularly known as schools of legal theory or jurisprudence. These schools are namely a philosophical school of jurisprudence, analytical school of jurisprudence, historical school of jurisprudence, and sociological school of jurisprudence. I hope that you have got a general idea regarding this concept. See you again. Thank you.